A lot of folk assume that if you own a caravan, van or mobile home, you can simply put it on land and live in it. But that doesn't really match how things go in practice, because the law often treats the structure one way and the way you use it another. A caravan might not legally be a building, yet living in it can still trigger planning enforcement. Because once you actually try to live on land full time, outside the conventional housing system, the rules start changing. If your home isn't legally a building, why can living in it still get you into trouble? Living on the road, waterways or off-grid in the UK, Dickie Dread. And this is part 12 in the video series, still in chapter 1, types of travellers and off-grid folk. So today we're going to look at the legal definition of a caravan or mobile home. So in UK law, the definition of a caravan is set out primarily in the Caravan Sites Control of Development Act 1960 and was later refined by the Caravan Sites Act 1968. A caravan is legally defined as any structure designed or adapted for human habitation which is capable of being moved from one place to another, whether by being towed or by being transported on a motor vehicle or trailer, and any motor vehicle so designed or adapted. The 1968 Act clarified size limits for what qualifies as a caravan, including mobile homes. So the maximum length is 20 metres. The maximum width is 6.8 metres, and the maximum internal height is 3.05 metres. Structures within these limits can still be considered caravans, even if they are delivered in sections and assembled on site, for example, twin-unit mobile homes, provided they remain capable of being moved. This definition is crucial because it determines whether a structure is treated as a caravan, or a chattel, or a building, which is development, under planning law. Caravans do not automatically count as operational development, but their use of land for residential purposes may still require planning permission. The legal framework is further shaped by the Town and Country Planning Act 1990, which governs the change of use of the land, for example, living on the land in a caravan. The Mobile Homes Act 1983 provides rights and protections for people living in mobile homes on authorised sites, and the equivalent provisions apply in Scotland under the Town and Country Planning Scotland Act 1997 and in Northern Ireland under the Planning Act Northern Ireland 2011. England and Wales share a broadly similar planning structure under the Town and Country Planning Act 1990, but Scotland and Northern Ireland operate under separate systems with their own legislation and policy frameworks. In Scotland, planning is governed primarily by the Town and Country Planning Scotland Act 1997 and the Planning Scotland Act 2019, supported by the National Planning Framework, what's called NPF 4. In Northern Ireland, planning operates under the Planning Act Northern Ireland 2011, with policy set through the Strategic Planning Policy Statement, which is the SPPS as it's known. While the underlying principles are similar across the UK, control of land use, requirement for permission and enforcement against unauthorised development, the detail of policy, terminology and decision making can differ significantly between the nations. So what constitutes a dwelling in UK law? So UK planning law does not rely on a single universal definition of a dwelling, but the concept is well established through the Town and Country Planning Act 1990 and extensive case law. In practice, a dwelling house is understood as a unit of residential accommodation used as a person's sole or main residence with the facilities required for day-to-day living. From case law and planning guidance, and there's some of that in the some references to those in the bibliography, a dwelling typically has three core characteristics. 1. The ability to live independently, not reliant on another building. 2. Provision of basic facilities, including sleeping, cooking, washing and sanitation. And 3. Use as a separate self-contained unit of residence. A commonly cited legal test comes from Gravesham Borough Council versus the Secretary of State for the Environment 1984, which emphasised that a dwelling must provide the facilities for day-to-day private domestic existence. So the key legal distinctions. The law distinguishes between a building used as a dwelling, such as a house or bungalow, a caravan or mobile structure used for residential purposes, and temporary or incidental accommodation, such as annexes, outbuildings, or structures for seasonal use. A structure can function as a dwelling in planning terms regardless of its physical form, though boats are treated separately under navigation law. What matters is how it is used, not just what it is made of. This distinction applies across all UK jurisdictions, and how it is interpreted can vary. Scotland and Northern Ireland follow similar principles, though case law, enforcement thresholds and policy guidance differ. In practice, this means that an arrangement tolerated in one part of the UK may attract enforcement in another, even where the physical setup is identical. This is why living full-time in a caravan on land can constitute a material change of use of that land, even if the caravan itself is not classified as a building. So why this matters. Whether something is treated as a dwelling determines whether planning permission is required, whether land is considered residential, whether enforcement action can be taken, and how rights, including traveller status, which we'll talk about later, or lawful use, are assessed. The distinction between a caravan and a dwelling is therefore not about structure versus non-structure, but about use, permanence, and independence. So, is there a minimum size for a dwelling? UK planning law, primarily under the Town and Country Planning Act 1990, does not set a minimum size for what counts as a dwelling. A unit can be very small and still be considered a dwelling if it functions as a self-contained place of residence. The legal test is not size but use. If a structure provides the facilities for day-to-day living and is occupied as a separate unit, it can be treated as a dwelling regardless of its dimensions. So where size matters. Although there is no strict legal minimum in planning law, size becomes relevant in other parts of the system. So national space standards. The government's nationally described space standard sets accommodation minimum sizes for new dwellings. For example, a one-person, one-bedroom dwelling needs to be 37 metres squared, and a two-person, one-bedroom dwelling 50 metres squared. These are not automatically binding. They only apply where a local authority adopts them through planning policy. So housing quality and enforcement. Under the Housing Act 2004, local authorities assess whether accommodation is suitable for habitation using the Housing, Health and Safety Rating System. Extremely small or cramped spaces may be considered a hazard, but this is about living conditions, not defining whether something is a dwelling. Caravans and mobile homes. As noted earlier, caravans are instead governed by maximum size limits under the Caravan Sites Act 1968, not minimum ones. A very small unit can still qualify as a caravan and still be lived in. Practical interpretation. In practice, this means a tiny home, van or small structure can still function as a dwelling in planning terms. There is no too small to be a dwelling threshold in law, and disputes usually arise over land use, planning permission, habitation standards, not size alone. Boats and floating dwellings. Boats do not fall within the legal definition of a caravan or mobile home. They are not governed by the Caravan Sites Control and Development Act 1960 or the Caravan Sites Act 1968, and they are not treated as caravans in planning law. Instead, boats are regulated primarily through navigation law, including the British Waterways Act 1995 and related legislation, as well as rules of relevant navigational authority. Their legal status is tied to licensing, mooring and navigation requirements rather than to land-based planning frameworks. A boat can be used as a person's sole or main residence, and in that sense it functions as a dwelling in everyday terms. However, this does not automatically make it a dwelling house in planning law. The key distinction is that boats are not fixed to land. Their occupation is generally controlled through Waterways legislation rather than through the Town and Country Planning Act 1990. Where boats are kept at permanent moorings, particularly residential moorings, planning considerations may still arise in relation to the use of the land or mooring itself. In those cases, it is the use of the mooring, not the boat, that may require planning permission. This creates a separate legal category alongside caravans and mobile home structures, governed through the caravan and planning law, buildings used as dwellings, governed through the planning law, and boats, governed primarily through navigation and licensing regimes. And I think you'll agree there, it's a pretty complicated case, but it's all laid out in the book, and I've tried to be as clear in the book as I possibly can and state all the legislation. So the law isn't primarily concerned with what your home is, it's concerned with how and where you use it. The real issue isn't caravans, boats, vans or tiny homes, it's control over residential land use, which means the question may not just be what counts as a dwelling, but who gets permission to live differently, and how much freedom do people really have to choose an alternative way of living. Okay, next up we will cover a lot of this in more detail in chapter 3. So next section is good. In chapter 1 is types of travellers and off-grid folk, still in chapter 1, and we'll cover traveller status, legal recognition, traveller status in planning law, and accommodation and planning. Okay, at last the books are now available, and you can get it by going to get a copy by going to that link or just contact me.